over to you two. Okay, thank you ever so much, Josh. Michelle, over to you.
Thank you, and good morning, everybody. Thank you for inviting us this morning. We are very excited about presenting the information and perspective that we have from the front lines. By way of background and who we are, we'll take a second to introduce ourselves. I'm Michelle Shuster. I've been practicing law for almost 30 years now. It's hard to believe I'm that old, isn't it, Josh?
It is. I never guess.
Yeah, and so throughout that period of time, I've had the privilege and honor of serving in many interesting roles. I was Consumer Protection Chief at the Ohio Attorney General's office when the do not call laws were being written and implemented in the early 2000s. As a result of that, when I left the AG's office and went to work at Big Law, I was very quickly pulled in by the industry to help industry figure out how to comply with all of those new laws and regulations. In 2007, we started Murray Shuster, and we have been very focused on any direct-to-consumer marketing and advertising legal issues, and me in particular, and Josh also in the telecommunications space. We are general counsel for PACE, a professional association for customer engagement. We have worked with CFCA on various committees on various issues. I will say, though, in our capacity today for purposes of this presentation, we are speaking on behalf of ourselves and in representation of other clients and not on behalf of PACE. Also, we will not be providing legal advice during the presentation, but are always happy to have those conversations as a follow-up. I will say also, before I turn it over to Josh, that in working as general counsel for PACE and also with clients in the telecommunications and marketing space, we have had a lot of experience with working with state and federal regulators. We have been involved in what we consider to be the important issues for industry as this industry has changed dramatically over the last 20 years, for sure. And especially in our capacity as being general counsel for PACE, we've worked and created the Communication Protection Coalition. And I know we had some folks that I see on this that were participating in some of those meetings. The purpose of that group was to help address some of the issues that were occurring when blocking and labeling initially started. It's probably been about 4 years ago now. Those of you on this presentation probably know better than I. We've also been very involved with US Telecom on various issues, and the blocking and labeling working group that's currently active. We have actively been involved with legal issues, including with the appeal of the 2015 FCC declaratory order, most recently in filing amicus brief in the Facebook case that was referenced by the Supreme Court in their decision in the Facebook versus Duguid case that dealt with defining an automatic telephone dialing system for purposes of the TCPA. We've also more recently been involved with filing amicus brief that is now interpreting Facebook and the illustrious footnote 7. If you don't know what that is, we're happy to talk about that in questions afterwards. But we consider ourselves educators. We meet regularly with the FCC, the FTC, state AGs to talk about these important issues. I consider myself an advocate for the industry, but I am also a consumer advocate at heart. That's where I started. That's where I worked. That's where we started with helping to draft regulations. We're excited to be here with you today and talk about some of the issues that we're seeing out there now. Josh, if you want to introduce yourself.
Yeah, sure. So I'm Josh Stevens. I'm a partner of Michelle's here at the firm. And like Michelle, I work primarily on the compliance side of things, right? Helping to educate clients on how to comply with all of these different regulations. And that's where I think the nexus really forms between that interest in protecting consumers while also advocating for our clients' needs is in that compliance space. And everyone who's on this call today, I think, the interest of trying to prevent fraud is something that we all see. Fraud is not good for the consumer. It's also not good for the business, right? And so we want to try to prevent those issues. And in today's conversation, where Michelle and I fit into this piece predominantly is at the platform or contact center level, right? So at that kind of originating point where those communications are being generated or being put onto the network. We represent a number of companies that are contact centers. We represent a number of platform providers, right? And I think it's important as we go through to remember that function or to remember the function of those two categories of businesses, right? A platform provider offers the software or the hardware, the technology to get a communication out into the world. They may or may not have great visibility into the content of the communication, right? They are an intro point. A contact center is often making the communication, right? That's why you hire them. You hire them to do the contacting. So they're going to have a little better visibility into the substance of a communication in many respects, but may also have some challenges with visibility into things like consent. If they're calling on behalf of a third party, often have to be reliant on that third party for that consent. And so when we're thinking about the ecosystem, and Michelle, I will say, told me I had to banish that word from my language, but I'm gonna use it anyway.
Given just this once.
But as we think about it, right, we're really talking at that very first step into the network, that first step into the communications chain during today's conversation, and how we can leverage that first step to prevent or reduce illegal call traffic that we all know plagues us. I get 10 calls a day wanting my social security number. So we all know that it's out there, and we want to try to prevent that from happening. And Michelle, I think one of the key parts to preventing that from happening is we have to understand on whose behalf are the calls being made, what is their role, what are they doing, right? That whole know your customer piece. And I know you've advised a lot of clients on that function. I'd love, your thoughts.
Yeah. And, know your customer is a popular term that's been out there for a while now, as we've talked about responsibilities of call originators and also carriers that are involved in the telecommunications chain. So I think everybody's got their own definition of it, but at the heart of know your customer, you truly have to know your customer, and you have to understand their business. You have to understand what their calls are. You need to ask questions about consent. You need to have contractual obligations on both sides that are going to prevent fraud and prevent bad traffic from being originated into the telecommunications system. Know your customers become much more important as voice service providers, and others that are required to comply with STIR/SHAKEN are registering with the robocall mitigation database. As part of that, providing information on your due diligence process. So we have been working with a lot of voice service providers, contact centers on these types of compliance programs. And it's a process that is a lot like doing due diligence in business in general. It's understanding who your client is, who the owners are, knowing that they have a physical location. Generally, they should have a website that provides contact information about that business. They should have bank accounts which are identifiable for purposes of making payments for services that are offered. Checking to see what the Better Business Bureau has on file related to that customer, and if there's a poor rating or consumer complaints that might raise some red flags. Also searching on Pacer to see if there have been lawsuits that have been filed against this company that would indicate that you would run into issues with their origination of telephone calls. The FTC has a database with all of their enforcement actions, and so looking on there to see if they appear. Also, just a general Google search, just a simple, good old-fashioned Google search on the company name and the business owners. And so obviously we work to document the processes and procedures for conducting this due diligence and knowing your customer. But also an important part of that is once you've onboarded a customer, we're very clear with clients that that's not the end, that's just the beginning, because there is an ongoing due diligence obligation. And Josh and I tend to refer to certain factors as high risk factors that would require you to have some additional conversations with that client to make sure that you're on the same page about what type of traffic is legal and wanted and would be originated by the voice service providers or the contact centers. And so some of the things that trigger red flags for us that would elevate the risk and require an additional due diligence review would be if the client was receiving, if our client, we'll just say voice service provider or contact center is receiving complaints from regulators, if they are receiving requests for information, subpoenas, CIDs from regulators, if there are litigation holds that are being issued because of litigation that's being initiated, checking the FTC known caller database to see if there's a large number of complaints against the client or the telephone number DID that's being used by the voice service provider or contact center's clients. So things of that nature. And if that should happen, that requires that the voice service provider or contact center do some additional review, ask more questions about the campaigns. Why are these complaints being originated? You might want to ask more questions about consent. What type of consent do you have to place these telephone numbers, or what type of interest has been expressed by the consumer to receive telephone calls so that these calls can be identified as legal and wanted. And Josh, I know in the day-to-day work that you've been doing with clients, you probably have some additional stories and context you can add to that.
Yeah, and so let me share just a few anecdotes of having put this into practice. One is it is critical to perform the due diligence on the officers, the management, the owners. In that know your customer process, stopping with the business is not enough. What we have found through experiences, and I'm sure many of you on today's session found as well, that often someone will run a campaign, get into trouble, they'll shut that business down, give it 6 months of cooling off, and then they'll start up something else. And if you're only searching the name of the business, then you're going to miss potentially complaints or enforcement actions that were against the ultimate owners, officers, and managers that should be red flags for you. And it's not to say that people can't change their ways, right? But we want to be more cautious, trust but verify, right? We want to be more cautious when working with someone who's had prior enforcement actions. Dig a little deeper into what they're proposing to do using your contact center or your platform before authorizing that activity. And as Michelle mentioned, continuing to do that due diligence on a regular cadence to update it at least once a year, if not more often in a normal scenario, not an enhanced model, because things change, right? You may have a contact center that's making calls on behalf of a company under a certain consent model, and that consent model changes over the course of a year to different lead forms, different lead sources, and you might need to understand that because that might impact how their compliance program works. We'll tell you, we we've had a situation I can think of with a platform provider where that platform provider was serving a contact center. And so if you think about this from a due diligence standpoint, that gets really tricky because the platform provider is serving someone who's serving other people. And so how do you follow that all the way through the chain? And the clients of the contact center are likely to change over time. And so how are you making sure there's a process in place to be updated when those changes occur? And so it's important to always remember where you sit in the chain and the visibility that you're going to need. And when we get to the enhanced review stage, when a red flag has popped up, in practice, this can be somewhat challenging to do, depending on how deep you want to dig. So what we typically recommend is pulling, for example, a sample of calls and then requiring the client, the end user, to provide the consent that backs up those calls if they're the types of calls that would likely need consent, including providing the consent language or the landing pages that the consent came from, so can take a look at it. If we feel a little uncomfortable, we've actually had clients who have asked their clients to get opinion letters from counsel to say, these forms provide consent, and the way that these calls are being conducted is being done in a compliant way. And sometimes, for example, with ITG, we might provide that documentation to ITG as a risk mitigation measure to show that we put this person through this process. Yes, there are complaints coming in. We know there are complaints coming in. We've heard those complaints, but all the information we're getting back is saying these are legal calls. Now, you can have the debate about legal versus wanted, right? And whether, these calls may be wanted or not, but this is what we're getting on the legal side. And
which puts people in an interesting position, right? Right,
does.
Josh? And this is something that we deal with occasionally when you're having to assist clients with responding to the ITG or industry traceback group requests, or in this heightened due diligence that Josh is describing, because it puts, and we'll just say voice service provider, in an interesting position, and that they really need to be, the investigator, the jury, and the judge in determining whether there's a real issue here that needs to be rectified immediately. And there is no bright line. This is not a black and white area. There is gray there. And in being put in that position, and we'll spend some more time talking about this, there are interesting situations that arise from a regulatory compliance standpoint for the voice service provider, from a legal contractual standpoint between the voice service provider and their customer. As a result, they are frequently put into a difficult position as they're trying to navigate this new world that we all live in, that's developed since the Trace Act.
Yeah, and as you can imagine, there's often resistance that has to be overcome by companies when they're asked to invest in getting an opinion letter from counsel, right? Counsel those letters don't come cheap. So there's often some, right, because there's risk to them. And so there's often some resistance to that. And you have to navigate that resistance to be able to get to a point where you feel comfortable. And I think this is true in any due diligence situation, where you can feel comfortable with what's going on, while also maintaining that client relationship. Because Michelle, you're exactly right to that point. It puts you in a tight situation. One of the other things I think is important with the enhanced review is, as you're going through it, you need to see commitment by the company to go through the process. We worked before with clients who have been trying to put their clients through the process and they get stonewalled, right? Messages aren't getting returned, calls aren't getting returned. And you know what? That is in and of itself a red flag. That shows that this company isn't committed to compliance, hasn't put the investment in, and maybe you need to turn them off, right? And nobody wants to cut off a client, but sometimes it's just what you got to do. Or instances where you see red flags that may indicate someone's trying to hide the ball, right? And so you're getting very cagey answers. You're not getting straight data. Those types of things, say in that enhanced review process, this might be an issue. When you get to the end of the enhanced review process, though, I think that is also a key juncture, because if you, as the voice service provider, the contact center, you've decided, okay, we're going to keep this client. We feel comfortable with what's happened here. What do we need to do going forward? So maybe you put them on a more frequent cadence for updating the due diligence review. So maybe you do that quarterly instead of annually. You sample calls on an ongoing basis and ask for consent data. We have advised clients before to have a contract addendum signed that essentially says, here's what you're committing to. These are the checks we're going to put in place every quarter. And if you mess up any one of these checks, you're gone. That's it. We've gone through the process. We saw some risks, you buttoned them up, but we got to make sure that you keep them buttoned up moving forward. But again, to Michelle's point, and I think this is a nice way to start talking about this, is where does that put you with that client relationship? And now you're having to police your client when you're not their lawyer, right? You're not their in-house counsel. You're not their compliance officer. You obviously have to feel comfortable with things, but at the same time, that gets balanced. That really has to be balanced against the fact that illegal calls, yeah, those are prohibited, right? We don't put illegal calls on, but maybe some calls that are technically illegal but unwanted, where do you draw that line? And that's really tough.
Yeah, it can lead to some interesting situations. Some of the situations that we have been involved in have brought into issue contractual provisions. So the voice service providers are entering into contracts to provide services to their clients. Generally, there's a cancellation clause in that contract that allows you to cancel service if a certain period of time is given by way of notice. So maybe a 30-day notice, so that they can switch to a different voice service provider. There can be a provision in there that if you breach the contract, all of which, at least nowadays, require that you comply with the law. So would allow for cancellation if there's a breach of contract by way of violating the law. And some of those contracts might have a right to cure as well. And so as you're navigating through this process and coming to the determination that, this is somebody that we really have decided that we are going to stop providing service, and the lawyers get involved after you provide a notice that their service will be terminated. Sometimes it's immediately, sometimes it's within a week. And then conversations have to be had about whether the contractual obligations are being met. And you might all be thinking, well, it's easy. If there's an issue, then they have to be violating the law. Well, sometimes complaints are received and maybe they haven't violated the law. They've done those things that Josh has talked about. They have a lawyer that has said that this is what their process is. This is what their compliance process is. This is how they get consent. This is the validated consent. They are not violating the law. And then you might get into conversations about, well, this is what the FTC thinks consent is, and this is what the case law is on consent, and this is what the state law is on consent. And those become complicated issues for courts, let alone attorneys, voice service providers that are trying to navigate through these difficult issues and trying to terminating a contract that isn't going to create additional liability for voice service providers. So those are real world issues that arise, and not infrequently in these types of situations. Also, on the other the other extreme of this, from the contractual issues, are issues potentially with regulators. I know from our experience with onboarding clients that have developed this issue, that the Federal Trade Commission is issuing a what I would call an unprecedented amount of subpoenas, civil investigative demands in this area. And the common denominator that we are finding is that companies that received ITG requests are then receiving civil investigative demands from the FTC. And I'm sure, as everybody knows on this call, responding to a civil investigative demand is a complicated, time-consuming process that will definitely distract companies from their main business and focus on business in order to respond to the civil investigative demands, which frequently go back 2 to 4 years and require that you review all correspondence that, for instance, might mention the word pre-recorded message in it, and that would be all client communication as well as internal communication. As you can imagine, that is a very tedious process and costly from the perspective of reviewing that many documents. The fear that is put into a company that has received a civil investigative demand in working with these business owners, and frequently they're not big corporate entities. These are entrepreneurial type companies that for the first time ever are facing an issue with a regulator that could lead to the business folding. And even if it's not a civil investigative demand or a formal enforcement action, we've all seen recently the FCC's issuance and threat of issuance of cease and desist orders. And I can tell you that the companies that received those cease and desist orders had a significant, or notice, I should say, it was a press release on the initial ones that were named in that press release. They had a significant reduction in business after that, and some of them are no longer ongoing entities. So this is all a very complex situation that we're all trying to deal with through implementation of STIR/SHAKE and through the efforts of the carriers with blocking and labeling, through the creation of databases to track calls and companies and complaints. And a lot of this is falling on those voice service providers, on the contact centers, with the very real threat of either a regulatory civil investigative demand, potentially regulatory enforcement action, or maybe even just bad press for originating traffic that may be legal, but not the type that regulators are happy to see being originated. So complex issues.
You talk about the fear factor, right? The fear factor of what if you receive an FTC CID or an onerous state subpoena or an FCC cease and desist. But there's also the fear factor of losing access to the network. And when you receive the carrier complaints, right, and trying to be responsive to those, while also understanding that a lot of times those complaints may be related to legal but perhaps unwanted calls by the consumer who complained, but the call's actually legal, right? And if you turn off every client the moment you get a carrier complaint, you're going to have no clients eventually. But speaking from experience with our clients, getting those notices from the carriers keeps them up at night. They're really worried about losing access to the network if they're not dealing with these issues as quickly as the carriers want. And like you said, Michelle, a lot of these companies, they're not really large. So to shift to addressing one of those notices, whether it's from a carrier or FTC or a state, means they've got to pull somebody from something else, right? So a lot of times, so we help a number of clients respond to subpoenas that they get from states. When those subpoenas come in, they typically have to pull someone off of their other IT duties, maintaining the system or maintaining the business, to go pull the records to respond to the subpoena. And that's not an insignificant cost. And please don't take this as me trying to say, don't send notices, don't send subpoenas or anything like that. That's not what I'm saying. But I do want to just make sure that everybody's aware, when you're dealing with these smaller companies, they often don't have teams dedicated to these issues. And so there's a more significant hit to their business operations when they have to deal with, notices that come in, than a company that may have dedicated staff to handle and process those notices.
That's an excellent point. Excellent point. I see that we only have 10 minutes left. So I do want to make sure that we're saving time for questions. Something also just interesting that Kevin Rupee, who was former in-house counsel to US Telecom, and I'm sure most of you on this phone call know, shared with me last week involving Marriott. And Marriott was the victim of somebody using their logo and also making telephone calls using their brand name. And so they've filed a John Doe lawsuit in Maryland and are working with, it's my understanding, with the carriers, with the industry traceback group to determine who's making the telephone calls, and then they fully intend to take action in that regard. And so I thought that was interesting. This is another area where we're seeing the evolution of enforcement and stopping the illegal robocalls. And I was glad that Kevin shared this with me, but it's Marriott versus John Doe's 1 through 10. It was filed in the Eastern District of Virginia. If anybody's interested in sharing that, it's obviously a public document. Happy to share that. And then do we have any questions from the chat? No, we don't. We are going to stop recording at this point. So don't be fearful of asking questions. It looks like there's probably about 14 people. I would be fine with opening up the mics and having a dialogue as well if folks don't want to put questions in the chat box. I'm sure the information that we've provided, it's not news to anybody, but hopefully we've been able to provide a perspective of the voice service providers that you're working with, and the contact centers also that are working with voice service providers, and some of the situations that they're addressing and working through.